to this class on the right to equality assured through Article 14 of the Fundamental Rights chapter in Part 3 of the Constitution of India. Part 3 of the Constitution of India comprises the fundamental rights guaranteed for all through Articles 12 to 35. Of these, the right to equality or equality for all in India is guaranteed through Articles 14 to Article 18. Now let's take a look at the preamble. The preamble embodies the goal of equality of status and of opportunity. This idea of equality expressed in the preamble lays the foundation of Articles 14 to 18, and taken together, they lay down the general as well as specific principles of equality before the law and prohibit unreasonable discrimination. So what does Article 14 say? It states that the state shall not deny to any person equality before the law or the equal protection of law within the territory of India. The right to equality is the first fundamental right assured to the people of India. Thus, the general principle of equality is embodied in Article 14. In fact, Article 14 is also commonly known as the Equality Clause because of its wide ambit and applicability. Now, as we move forward, it is necessary to examine to whom does Article 14 apply, or who qualifies as any person as mentioned in the definition of the right to equality under Article 14. In India, equality before law is guaranteed to all without regard to race, color, or nationality. This article applies not only just to the citizen of this country, but to all foreigners. Even companies, corporations, or associations of individuals who are juristic or legal persons receive the benefit of Article 14. To sum up, the protection of Article 14 extends both to citizens and non-citizens, as well as the natural as well as legal persons. Let's flip the coin now and take a look at the exceptions to the rule of equality. Under Article 359 of the Constitution of India, when there is a proclamation of emergency, the operation of fundamental rights, including Article 14, can be suspended. That is, if any violation of the right to equality occurs during such proclamation of emergency, it cannot be challenged in the court once the proclamation ends. Under Article 361, the President of India and the governors in each of the states are also not held liable in any court for any act done by them in exercising their power and duties of the office. Also, the members of the Parliament, that is the Lok Sabha and the Rajya Sabha, under Article 105 enjoy immunity from any action that they may have done in the exercise of their power and duties of office. Similarly, the members of the state legislature, that is the Vidhan Sabha and Vidhan Parishad, in case of states with a bicameral legislature, or just the Vidhan Sabha in case of state with a unicameral legislature, will not be held liable for anything which they say within the House. Foreign diplomats and emissaries also cannot be held liable under Article 14. Let's take a closer look at Article 14. When it says, the state shall not deny to any person equality before the law, the first component, or the equal protection of law, the second component, they together make the right to equality. Let us examine each of these two components separately. The first expression, equality before the law, has been adopted from English common law. It is what is known as a negative concept. What this means is that no man is above the law, that every person, high or low, is subject to the ordinary law of the land. Every person whatever be his rank or position, is subject to jurisdiction by the ordinary court. It makes that law is blind. Law will make no distinction as to who is before the law. The eyes of law makes no distinction between the beggar and the king, between one who is of a privileged class and another who is not. It is therefore a declaration of equality amongst all people, and implies also the absence of special privilege in favor of any one single individual. Now, equality before law is the first principle of the doctrine of rule of law developed by Professor A.V. Dicey. Professor A.V. Dicey, who was a British jurist and constitutional theorist, was widely known for the rule of law doctrine in his book, The Law of Constitution of 1885. Explaining the concept of legal equality as operating in England, he said, "With us, every official, from the Prime Minister down to a constable or collector of taxes, is under the same responsibility for every act done without any legal justification as any other citizen. In other words, no man is above the law. There is thus the rule of law. Law reigns supreme, and it means that no man is punishable or can be made to suffer except for breach only of the law of the land." With that, we come to the second component of the right to equality. The second component of the right to equality is the equal protection of the laws. It is based on the US Constitution. To be precise, the last clause of the first section of the 14th Amendment Act to the US Constitution incorporates the doctrine of equal protection of the law. It is a positive concept. What that means is it expects there to be a positive action from the state, a guarantee from the state of equal treatment. The state will provide for equality both in privileges conferred and liabilities imposed. Thus, all persons will be treated alike by the state based on reasonable classification. Dr. Jennings explains this most lucidly. He says, "Equality before law means that among equals, the law should be equal and should be equally administered. That like should be treated alike. The right to sue and be sued, to prosecute and be prosecuted for the same kind of action should be same for all citizens of full age and understanding, without distinction of race, religion, wealth, social status, or political influence." It therefore underscores equality of treatment in equal circumstances. In other words, all persons who are in the same circumstances will be governed by the same set of rules. The rule is that like should be treated alike, and not that unlike should be treated alike, because that indeed would lead to discrimination. Hence, equal protection of the law means that there should be equal treatment. Now, saying equal treatment, will that be the same as saying same or uniform treatment, or even identical treatment? Let us examine this through an example. Consider a racetrack. You may have seen that the athletes start in different spots in each of the lanes. This is so that the athlete on the farthermost lane from the center is not unduly disadvantaged. This ensures that every athlete covers distance which is same for all, therefore ensuring equality of treatment. Thus, it is not necessary that every law must have same or uniform application, that every athlete must start from equally same spot on across the lanes, because people are different in terms of their nature, in terms of their attainment, in terms of their circumstances. and therefore the state can treat different persons differently, given that the circumstances justify such treatment. In fact, identical treatment in unequal circumstances would amount to inequality. Therefore, what is required is equal treatment in equal circumstances. Hence, it is actually necessary to perhaps group or classify persons so that we can attain specific welfare aims. Article 14 thus provides for what is known as reasonable classification. Reasonable classification means grouping of persons into classes based on their common circumstances. Thus, there is a rational basis for such classification. Now, a reasoned classification must always fulfill two tests, or it must be based on the two elements of intelligible differentia and rational nexus. When we say intelligible differentia, what we mean is that there should be some factor which distinguishes persons grouped together in one class from another left out of it. In other words, there should be some rational basis and not some arbitrary or artificial object as to why persons have been classified or distinguished in the first place. When we say rational nexus, what we mean is that there has to be some sort of a nexus or a negotiation between the differentia for classification and the object of the law or the reason that seeks such classification. Now, this is very different from what is known as class legislation. Class legislation, indeed, is a discriminatory practice. It is a practice of arbitrarily grouping together certain persons or classes. It confers special privileges or particular privileges unfairly upon a class of persons arbitrarily selected. There is no reasonable distinction justify why one has been included and the other has been left out of such privileges. In other words, what Article 14 does is it prohibits class legislation and it permits or encourages classification for the purpose of welfare legislation, indeed considered necessary if society is to progress. Thus, the right to equality is not only a primal feature of the Constitution, but perhaps one of the most dynamic concepts having many facets. While one of the facets is that there shall be no privileged person or class and none should be above law, the other facet also emphasizes upon the obligation of states to bring about, through the machinery of law, a society where all are meted out justice. In fact, it is one of the most important areas of basic structure of the Indian Constitution. In the case of Indra Sone versus Union of India of 1993, the Supreme Court declared that equality is one of the magnificent cornerstones of the Indian democracy.